Alrighty, this is We the People News, okay? Not attorney, not giving legal advice, education only, okay? I do want to bring out, allegedly, in Texas, okay, our Attorney General is allegedly a traitor. And why do I say that? Because he signed a contract with the federal government to intervene in uh, our state's private affairs for the 4D program, Child Support Agency. Okay, and uh, and then when he knows that families that cannot afford it cannot fight it in a honorable way, right? Because these judges, these magistrates, are not honorable. Okay, but it's due to our ignorance that we turn around and we enter the court not thinking it's a contract. We thinking it's some type of law, and the Attorney General knows this. So he's misleading you. He's also went and signed a contract behind our back to the federal government to waive our rights. And I'm led to believe that that's a traitor, okay? Because he sold your rights from underneath you. And then your county enters a contract with the AG's office, which is Kim Paxton's here in Texas, right? Well, now your county is a traitor as well, because behind your back, again, they're signing a private contract with the Attorney General, which in turn signs a private contract with the federal government, which in turns that we all think this is all law. When in all actuality, we're agreeing to some form of contract. Okay? And billions of dollars in Texas. And they're against the mom, they are against the dad, and they are against the offspring to help their bank account. Just wanted to point that out, okay?
Is over all the executive departments and agencies, all the alphabet soup that we have on both state and federal level. He's the chief executive. So if he's the chief, then no federal agent has greater power than the president. They can't have more than he has. Next. Therefore, number 6, no member of the executive branch may restrict the rights and powers of the people of the states other than by laws authorized by Article 1, Section 8. As you can see, Article 1, Section 8 is the total power. Next. Therefore, we can conclude, and here's a shocker for many people, executive orders. Do we have to follow that executive order? Well, listen, friends, I'm going to tell you. Executive orders are not called executive orders because they're issued by an executive. They are called executive orders because they bind only the executive branch. An executive order only applies to the people under his control.
Which is not the people. Same thing with your government or governor, right? Their executive orders does not apply to the people. It only applies to the underlings, your cops, during an emergency, state of emergency, like, and Trump and Biden and all them, I'm signing an executive order, okay? Well, if it applies to the people, they're not presidents, they're kings. If a governor can sign an executive order against you, then they are the king of that state. They are not the governor. And since we have no kings, then that executive order must only apply to the government body, which is the creature of the state or the creature of the federal government. Not complicated.
The people are not under his control. The General Assembly, the Congress is not under his control. The courts aren't under his control. An executive order only controls the executive branch. It's very plain. There's misunderstanding about this topic all across our country. Next.
Yeah, see that? The governor has no authority over your judges, even at the time of, bad things happening in your state. It's just, kind of getting out there, the emergency people and all that kind of stuff to kind of help your state out of during an emergency. What they are doing is using that administrative to force onto you by your ignorance. And then you go to court. Well, the court's not on your side because they are administrative, which, by the way, is conflict of interest are conspiring because another agency against another agency telling you to do this is conspiring. You know, if a court says something and then another court says something, that's not conspiring. Or if CPS says something and CPS, in that guidelines of the statute, is not conspiring. But if CPS goes to the hospital and has the hospital do something, now that's conspiring, and then they take the kids away at the hospital. It's conspiring because it's two different agencies, and one agency is using another agency to do their bidding.
Now let's look at the courts. The states gave the judicial power to one Supreme Court.
Oh, by the way, I'm not an attorney and I'm not giving legal advice. Do your own research on that, okay? I may be wrong. I'm hearsay. But this is the interesting part here itself.
And in such inferior courts as could be later ordained and established. Look at Section 2. How far does the judicial power go? It shall extend to all cases. Notice the word case is important. What is a case? That's where there's party A and party B, and sometimes C, D, E, and F. But their authority extends to a case that's before it. And what cases can it hear and decide? Cases in law and equity, but those cases must arise under this Constitution or under the laws of the United States and treaties made, which are made under their authority. Again, Article 1, Section 8 limits the kind of cases that the federal courts can hear. Next. So, conclusion, courts have no legislative powers, but only judicial powers. Judicial powers relate only to the duties of rendering a judgment in a particular case. That's what judges do. They decide who wins and who loses. Number 3, because judicial powers are limited to cases under the Constitution, the federal courts do not have power to judge any case whose subject matter lies outside of the scope of Article 1, Section 8, since Congress cannot make laws beyond the scope of Article 1, Section 8. Thus, federal courts have no power to restrict the rights and powers of the people or states, other than by laws that are within the text, the subject matter, the scope of Article 1, Section 8. Next. Now, here's another shocker. Nowhere in the text of the Constitution are courts given the right to interpret the Constitution, nor are the courts given the right to declare what is constitutional. I want us to stop right there for just a minute. The typical member of the American public, and I'm afraid even the typical member of the bar, thinks that the main reason we have a United States Supreme Court is to tell us whether something's constitutional. We even had a Speaker of the House a decade or so ago that said, we've got to pass the law first to find out whether it's constitutional.
That was Pelosi, by the way, y'all.
Utter nonsense. Nowhere in the Constitution is the Supreme Court given the authority to declare what is constitutional, nor is it given the right to interpret the Constitution. So we ask ourselves the question, how'd they get that right? Next. Well, in support of my proposition that they took this right for themselves, a pure power grab, I will quote to you, as you know, the extreme right wing, Justice Sotomayor of the United States Supreme Court. A fellow right-winger like me. Well, I don't say that in jest. She's not right-wing at all. She's from the liberal establishment of the court. I want you to hear what she said in the case that overturned Roe versus Wade, the Dobbs versus Jackson. Here's a quote. She says, counsel, she's arguing with the counsel that's trying to overturn Roe versus Wade. And so by way of argument, she says, there's so much that's not in the Constitution, including the fact that we have the last word. Marbury versus Madison, the case where they took the power. There is not her.
Now, sit and think about that. Marbury versus Madison, right? They made an executive decision and made a law that gave them power that they did not have. So, in all actuality, Marbury versus Madison is null and void. Even though it's got some good stuff in there, over the whole grim of things, Marbury versus Madison was unconstitutional on its face, and it's null and void. And how would we be able to do this with the judges and the Supreme Courts and all that? Well, we go back into the old cases before Marbury versus Madison. How do they do it then, y'all? I mean, they actually had real judges back then. Now, that being said, they did some good stuff as well. But at least they knew the people was sovereign and the people was the authority. But after that, what happened? We slowly lost our authority and became subjects.
Quote, there is not anything in the Constitution that says that the Supreme Court, is the last word on what the Constitution means. It was totally novel at that time, and it was. And yet, what the court did was reason from the structure of the Constitution that that's what was intended. You understand what she's saying? We used our brain to decide we could do that. Someone needs to decide. So what I say in my presentations, they say, mirror, mirror on the wall, who's the wisest of them all? Well, it must be us. And so we'll decide. A raw power grab. That's exactly what they do. And they continue to do that. They reason from the structure of the Constitution.
But sit and think about it as well, y'all. So, I don't care if they're liberal or Republican, whatever. They're supposed to just follow the guidelines of the Constitution, okay? Period. And I'm a firm believer they should not be called liberal or Democrats or Republicans. I think they ought to be just called running for the Supreme Court or this, that, here, and there. Because they're not supposed to be biased. If you're a Republican, you're biased. If you're a Democrat, you're biased. But they're not supposed to be biased. You're not supposed to have a Democrat or a Republican judge. Period, y'all. Okay? That's number one. Okay? Number two. It took overturning Roe versus Wade for them to bring that back up that, hey, we're saying it's constitutional or unconstitutional because Marbury versus Madison says we can when it's null and void, people.
They've reasoned from the 14th Amendment and created a quagmire of nonsense through the incorporation doctrine. Another, for you lawyers, incorporation doctrine, totally made up. Has no basis in the Constitution, has no basis in reason or in a republic, quite frankly. Anyway, they reason from that. So next slide. And I was going to let you hear it in her words, but we may not be able to get that to play. So I think if we can't get it to play, we'll skip it. If you want to hear it, you can hear her say that in her own words, admitting that there's no authority in the Constitution for the courts to decide that. So let's move on in our slides. Each of the first three articles of the Constitution make it plain that the states did not give up all rights to the federal government, a government which the states and the people had created. Next. Is there any other evidence we need to consider in evaluating whether states are supreme? Do they have rights? The answer is yes, the Bill of Rights. Next. So next. The preamble is one of the things. I've got a pocket constitution here with a declaration. It's got the preamble to the Bill of Rights in it. Many of these documents do not put the preamble in. I never studied it in law school. I want you to look at what the preamble to the Bill of Rights says. Why are we doing a Bill of Rights? Look at what it says. It says the conventions of a number of the states having, at the time of adopting the Constitution, expressed a desire. Hey, are we going to adopt this Constitution? I'm concerned about something. They expressed a desire in order to prevent misconstruction or abuse of that's the Constitution, the Constitution's power, that further declaratory and restrictive clauses should be added. As extending the grounds of public confidence in the government will best ensure the beneficent ends of its institutions. Stay on that slide for just a minute. Let's go back there. Notice what it's saying here. Why do we have a Bill of Rights? Because we want to be sure there's no playing around with the language of the Constitution. We want to be sure that it can't be misconstrued. We want to be sure that the federal government is restricted. Notice restrictive clauses. Next. Note this. According to the preamble, Every single one of the 10 Bill of Rights was adopted in order to limit federal power. The intention was not to protect any or ensure any particular right, not your right to have a gun, not your right to have a free press. It's to tell the federal government they can't touch it. That's the whole purpose of the Bill of Rights. The intention was to protect that right from federal intrusion. That means the states would decide those issues. Next. Now let's look at the Ninth Amendment. I'm making good progress. Thank you for your patience. The enumeration, here's what the Ninth Amendment says. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained, notice the word retained, by the people. Next. 10th Amendment. The powers, Ninth Amendment again, is the rights. If the right is not specifically in the Constitution given to the federal government, it's reserved or retained by the people. 10th Amendment. The power, if we did not give power, okay, 10th Amendment is a power. The power is not delegated to the United States by the Constitution, nor prohibited. Now, the Constitution does, in some cases, prohibit the states from doing certain things. Look at Article 1, Section 10 for you lawyers. Article 1, Section 10 is the list of things states can't do. They agreed to give up certain powers. If it's not in there, then those things unstated, if it's unstated, they're reserved to the states respectively or to the people. Next. So the 10th Amendment analysis. The 10th Amendment sets in concrete the framers' view of the covenantal nature of government, by which government has only such power as we the people delegated to it through the written document, through the Constitution. Next. So in conclusion, it's very clear from these 7 constitutional provisions that states' rights exist. Surely, in light of this clear language, no one could argue otherwise. Right? Next. Wrong.
That being said, just in the 10 Commandments right there, or 10 Commandments, Constitution, right? And the articles he's talking about, we didn't even need the 14th Amendment. So if the 14th Amendment is here, why is it here? Okay? Because it's already in Congress in writing that if you become over here, you can become a citizen of one of the states. Not the federal government. They do the paperwork and they ask you which state you're going to live in and which state you're going to be a citizen of. But you cannot be a citizen of the federal government before then. It's all to the state.
There are 2 main arguments against what I've just told you. I only have time to make one today. That's the Supremacy Clause. The other one's the 14th Amendment. I wish I had an hour. I think.
All right, we're going to pause here on this one. I guess make one more. This We the People News. Bye, y'all.